Welcome to the Deep Dive, where we take your sources, unpack the essential insights, and, well, basically help you become truly well-informed.
That's the plan.
And today, we're embarking on a deep dive into an area of law that's, both critically important in the modern world and, let's be honest, often seen as pretty challenging. We're talking about intellectual property.
That's right. And the material we've got in front of us today is specifically designed to help you navigate that challenge. We're focusing on excerpts from a document called One Challenge of Intellectual Property, which has been very generously made available to students by the University of London.
Yeah, fantastic resource. And our mission today, really following this document, is to pull out the core knowledge about why this subject, IP law, presents these challenges. Understand the specific hurdles you might face, and, crucially, get a real grip on the most effective ways to study it successfully, especially if you're gearing up for academic study, maybe an exam in this area.
Exactly. This deep dive is very much tailored for educational purposes. The aim is to give you a firm handle on those foundational concepts and, just as importantly, the kind of strategic mindset you need to really tackle intellectual property law effectively.
And before we properly dive in, we absolutely want to give a big thank you to the University of London
Oh, absolutely.
for making valuable documents like this available to students. Their commitment to sharing these resources, it's just incredibly helpful for learners everywhere.
Couldn't agree more. And we're proud to say this deep dive, making use of their excellent material, is brought to you by Sinorbit Academy, Sri Lanka.
That's right.
And from both of us, we sincerely wish you all the very best of luck with your studies and, of course, with your upcoming exam. We really hope this session brings some clarity, maybe some confidence, too.
Definitely. So let's unpack this. Intellectual property law, you hear about it all the time, don't you?
Yeah.
Patents for new gadgets, copyright for music, films, books, trademarks for brands. It sounds incredibly relevant, super current. Yet this document from the University of London kicks off by highlighting that it's widely seen as, well, challenging by students. Why? What is it about IP law specifically that makes it a difficult subject to get your head around?
Well, the document lays out a really compelling case for why that perception exists, and it starts, perhaps surprisingly, with the subject's history. It's relatively recent arrival in the mainstream law curriculum.
Right. The source gets straight into why intellectual property law can feel like, well, a tough nut to crack when you first approach it. It wasn't always a core academic subject, was it? Not like, say, contract law or tort law that have been on the syllabus for centuries.
That's precisely the first point the document makes. IP was, comparatively speaking, a latecomer to the academic law scene. For many, many years, it was seen predominantly as a very specialized area, almost exclusively the domain of practitioners.
Like solicitors and barristers.
Exactly. People dealing directly with clients, inventors, artists, companies looking to protect their commercial assets. It just wasn't typically considered broad enough or fundamental enough for general academic study in the way that core subjects like criminal law or constitutional law always were.
And the document actually notes just how recent that shift really is. The first student textbooks, specifically on intellectual property law, only started appearing in the 1980s.
In 1980s, think about that. In the grand scheme of legal history and academic tradition, that's incredibly recent.
It really is.
A subject that's now pretty fundamental in many law degrees only began getting dedicated academic textbooks for students, just a few decades ago. And this recent integration means that academic structures, the teaching methods, even how the subject is sort of conceptualized in universities are, in a way, still maturing compared to disciplines with much, much longer academic histories.
Okay, and even though it's now pretty well established in undergraduate programs all over the world, the Force points out it's still heavily influenced by those practitioner roots.
By practitioners and the commercial demands of their clients.
Right.
And this is a really key characteristic, another source of the challenge, I think, because so much of IP law develops directly out of real-world commercial activity and, let's face it, disputes.
Companies fighting over brand names.
Exactly. Or inventors trying to lock down their tech, artists asserting rights over their work. The law is constantly being shaped by those very practical, very commercial needs.
Okay.
And the document sort of implies that this practitioner focus means the emphasis can sometimes feel less about abstract legal theory or big public policy debates, and maybe more about the nitty-gritty application of detailed rules to achieve specific commercial goals.
So it needs a kind of practical, business-focused mindset.
Often, yes, which can feel quite different from purely theoretical legal analysis you might find in other subjects.
Okay, so we've got a subject with a relatively short academic history, still strongly linked to commercial practice. That explains some of the background. But the document also highlights the sheer diversity of what actually falls under this big umbrella term, intellectual property.
Ah, yes.
It groups things like patents, designs, copyright, trademarks, breach of confidence, but then immediately says they have, legally speaking, surprisingly little in common.
This is a crucial point, and maybe the most significant challenge when you first dive in. While they're all conveniently lumped together as intellectual property because they deal with, intangible creations or assets of the mind and an idea, an invention, a brand, a secret,
Right.
the actual legal rights that protect them are fundamentally distinct. They work very differently. The scope of protection you get from a patent is completely different from copyright protection, which is different, again, from a trademark.
And the rules for how they're created, who owns them, how long they last, and critically what counts as infringing them, those are all separate for each type.
Totally separate. You might think, intuitively, there's a common set of principles with maybe slight tweaks. But no, that's not the case at all. The hoops you have to jump through to get a patent are utterly different from registering a trademark or how copyright just sort of arises automatically for certain works. And what counts as infringing a patent, like making or using the patented invention, is quite distinct from infringing copyright, maybe copying a chunk of a book or infringing a trademark, like using a similar logo that confuses people.
Okay.
And the document points out another layer here. Some of these rights are primarily statute-based. They come from detailed acts of parliament. Others are largely derived from case law, built up bit by bit through judges' decisions over many, many years.
So you're not learning one coherent body of law with different chapters. You're basically learning multiple distinct legal systems that just happen to be bundled together under one course name.
That's a very good way of putting it. Precisely. It really forces you to compartmentalize and understand the specific rules for each type of right. This fragmentation is a huge part of the initial learning curve.
Right.
And this leads us straight into the next layer of difficulty the document flags up. The specific hurdles presented by the detailed rules within each individual area of IP.
Okay, let's dig into those specific areas mentioned in the document then, and the particular challenges they throw up. It gives some really concrete examples that illustrate the level of detail we're talking about. First up, copyright. The source says the basic idea, protecting original works, stopping people copying them, that's relatively straightforward to grasp at first.
It seems simple on the surface, doesn't it?
Isn't? But the UK rules are apparently incredibly detailed.
Yes. This is where the saying, the devil is in the detail, really, really applies. You get the core concept. Don't copy someone else's creative stuff. But then, the document gives this stark example. The main UK law, the Copyright Designs and Patents Act, 1988, as it's been amended over the years, contains over 50 separate defenses to copyright infringement.
50? Seriously?
Over 50. Think about that. 50 different legal arguments or exceptions you might be able to use if someone accuses you of copying. And each one has its own very specific criteria, its own conditions that have to be strictly met.
Wow, 50 defenses. That's not just knowing the main exceptions like fair dealing. That's understanding a vast, intricate landscape of specific carve-outs and permitted uses.
Exactly.
That immediately tells you this subject isn't about just painting with broad strokes. It's about mastering those tiny, intricate details and knowing precisely which of those 50-plus defenses might actually apply in a specific situation. It sounds like it requires incredibly close attention to the exact wording in the act.
It absolutely demands that level of precision. Distinguishing between, say, fair dealing for criticism or review and fair dealing for reporting current events, or the specific exceptions for libraries or archives or educational use. They all have slightly different requirements you have to satisfy. Now, let's compare that to designs. The document says here, the law itself is complicated, perhaps in a different way than just having loads of defenses.
Complicated how? Specifically, what makes designs law so tricky for a student?
The complexity here seems to stem more from the sheer number of potential legal routes a designer might have to protect their creation. Unlike copyright, which mostly just happens automatically, or patents and trademarks where there's a clear registration process, design protection in the UK is described as a kind of multi-headed beast.
Right.
The document states a designer might have potentially 5 diverse means to get legal protection for what they've created. 5 different possible legal regimes or rights that could potentially apply to protect a single design.
5 different routes. For protecting what looked like just one thing, a design. That sounds confusing, even figuring out where to begin.
It really can be. And each of these 5 potential routes, which could include things like UK registered designs, EU registered designs, UK unregistered design rights, community unregistered design rights, and maybe even copyright or trademark protection for certain aspects of the design.
Wow.
Each of these 5 has its own distinct set of criteria for qualifying for protection in the first place, its own rules on who owns the right initially, how long that protection lasts, and the duration can vary wildly between them, and crucially, what specific actions count as infringement under that particular regime.
So the challenge for the student isn't just learning the rules for one type of design right, but understanding all 5 possibilities. And then if you're given a specific design scenario, you have to diagnose which rights might apply, check the requirements for each, and figure out infringement under each one.
Exactly that. It's a diagnostic exercise. You get the facts about a design, and you need to analyze it to figure out which of the legal boxes it might fit into, maybe even several boxes at once, and then apply the specific rules for that box or those boxes. It demands a high degree of analytical skill and a really clear understanding of the scope, the requirements, and the potential overlap between all these different rights.
Okay, moving on then. Trademarks. These are like the badges of origin, aren't they? The way businesses communicate with consumers.
Yes, things like a brand name, Google or Cadbury, or a logo like the McDonald's searches.
Or slogans.
Yeah.
Packaging shapes.
Potentially, yes. Slogans, distinctive packaging shapes, maybe even sounds or colors, as long as they actually function in the marketplace to distinguish the goods or services of one company from another. And the document highlights a really fascinating challenge here. Whether a particular sign, a word, a logo, whatever is legally capable of being registered as a trademark in the first place, or whether, once it is registered, someone else's use of a similar sign counts as infringement. These issues often depend heavily on the court's view of how words and other symbols are actually perceived and understood by English consumers.
Ah, so it's not just a technical legal test.
Yeah.
There's a big element of subjective interpretation based on how the public sees things. It's not just comparing signs on paper, but how the average person would react seeing them in a shop or online.
Precisely. The law is constantly asking questions like, is the sign distinctive enough in the public's mind to actually work as a badge of origin? Well, is there a real likelihood that consumers will be confused between these two brands? Or does this new sign unfairly take advantage of or harm the reputation of an established trademark?
Right.
Answering those questions forces the court, and therefore you as a student, to step into the shoes of the average consumer and assess likely perception and reaction. And the source points out a specific, maybe less obvious challenge here too. For people for whom English is a second language, grasping the really fine nuances of meaning, the connotations, the associations conveyed by certain words or symbols might be quite difficult.
That makes sense.
Trademark cases can often turn on very subtle linguistic points or visual distinctions and how they play out in the psychology of the consumer. It demands a real sensitivity to language, culture, and how symbols work in a commercial context.
Yeah, you're kind of grappling with linguistics, maybe psychology, marketing ideas, all layered onto the legal rules. Okay, finally, patents. The document says the core legal principles here, what you can patent, what counts as infringement, are often described as quite straightforward. But apparently, many students find the cases themselves really difficult to read and understand.
This is very often where what the document candidly calls techno-fear comes into play.
Techno-fear, okay.
Yeah. Many law students, quite understandably, come from backgrounds in the humanities, arts, or social sciences. They probably don't have degrees in engineering or chemistry or software development.
Right.
So when they encounter a patent case that's discussing, I don't know, a complex pharmaceutical compound or an intricate bit of mechanical engineering or a sophisticated algorithm, they can feel immediately intimidated.
Yeah, I can absolutely see that. Opening a judgment about, say, gene sequencing or microchip design and being hit with pages of highly technical jargon would be pretty daunting. You'd think, I don't understand the science. How can I understand the case?
It is daunting, and that feeling of being completely lost in the technology is what the document labels technofear. But the crucial insight, and the document is very clear, and I think reassuring on this point, is that you should concentrate on the legal principles, not on trying to become an expert in the science itself. It is not necessary, the guide stresses, to have a PhD in biotechnology or mechanical engineering to understand the law of patents. Your job as a law student is to understand the legal rules about novelty, inventive step, infringement, sufficiency, and then apply those rules to the facts as the court describes them, even if those facts involve complex technology.
So you need to understand what the invention does at a basic functional level to apply the law.
Exactly, like this drug treats this condition, or this machine performs this task.
But you don't necessarily need to understand the deep science of how it actually works.
Precisely. You don't need to understand the molecular interactions or the precise engineering tolerances. You focus on the judge's legal reasoning, how they apply the legal tests to the factual description of the invention provided in the case. The focus is law, not science.
So the challenge isn't actually mastering the science, but maybe overcoming the fear of the science and keeping your analytical focus squarely on the legal rules and how they're being applied to the invention's function.
Exactly. It's about deploying your legal analysis skills, the ones you use in every other area of law, just applying them to a sometimes technically complex factual background. Don't let the tech scare you away from the law.
Okay, so let's just quickly recap where we are. We've got this subject, IP law, relatively new academically, born from commercial practice. It's fragmented into these distinct legal rights, patents, designs, copyright, trademarks, breach of confidence, and each one has its own specific complexities and challenges.
Yeah, like the sheer volume of defenses in copyright,
Yeah.
the multiple protection routes for designs, the subjective perception issues and trademarks, and this techno-fear element in patents.
Right. And then the document mentions another major layer of complexity,
Mhm.
the very diverse and constantly shifting sources of this body of law. It's not all made in the UK Parliament.
No, definitely not. This adds another substantial dimension to what you need to get to grips with. As we touched on, some areas are almost entirely homegrown products of English law. The document specifically mentions the tort of passing off.
Which protects business goodwill.
Exactly. Protects against people misrepresenting their goods or services as being connected with yours. And the action for breach of confidence protecting secret information. These are primarily products of English common law.
Meaning they've evolved over centuries through judges' decisions in court cases, building up precedent.
That's right. They are classic case law subjects. So, to understand them, you have to get comfortable reading and digesting a large number of judicial decisions. Sometimes you need to read quite old cases to grasp the foundational principles, and then trace how those principles have been adapted and applied in more modern situations.
So you really need strong case reading and analysis skills for those areas, understanding how the rules have developed incrementally.
Absolutely. You're essentially learning the law by seeing how judges have resolved past disputes. But then, on the other hand, the document stresses that the other main areas of intellectual property, so patents, trademarks, copyright, registered designs, these have been profoundly and heavily influenced over the last, say, 3 decades by international agreements, international conventions, and particularly by secondary legislation coming from the European Union.
Okay, so that means you're dealing not just with UK Acts of Parliament and UK court decisions, but also international treaties, EU regulations, EU directives, and the court cases that interpret all of those different sources.
Precisely. It means you have to be adaptable. You need to get comfortable reading different styles of lawmaking, the often quite broad principles in an international convention versus the very detailed, directly applicable text of an EU regulation versus a UK Act of Parliament that's trying to implement the goals of an EU directive. And you also need to adjust to different judicial methods of interpretation used by different court systems. Key cases explaining some of this legislation might come from the UK courts, applying their traditional methods of interpretation. But equally, crucial interpretations might come from the EU courts, the Court of Justice of the European Union, the CJEU, and the General Court.
And their way of interpreting might be different, maybe more focused on the overall purpose of the EU law.
Often, yes. Their approach can be influenced by the civil law tradition found in many member states, or by the specific objectives of EU harmonization, which might lead to slightly different reasoning compared to a UK common law judge.
And the document makes a specific point here, doesn't it? Even after Brexit, decisions from those EU courts still have significance in the UK.
They absolutely do. This is a really important point.
Mhm.
The UK kept a large amount of EU law on its statute books when it left the Union. This is often called retained EU law. And that retained EU law, including regulations and directives relevant to IP, often continues to be interpreted by UK courts by looking at the case law of the CJEU that existed before the end of the Brexit transition period. It's complex.
It's very complex.
And the document indicates this whole relationship between retained EU law and current UK law is a specific topic that's covered in more detail later in the full guide, section 3.3 it mentions. So that's clearly a crucial area you'll need to focus on in your studies.
Right.
And then, just to add another layer, the document points out that decisions about actually granting or registering IP rights, the administrative side of things, can come from several different offices.
Not just UK bodies.
No. You've got the UK Intellectual Property Office, the UKPU, which handles UK patents, trademarks, and designs. But you also have the European Patent Office, the EPO, based in Munich, which grants European patents. These can then be validated in individual countries, including the UK. And then there's the European Union Intellectual Property Office, the EU IPO in Alicante, which registers EU-wide trademarks and registered community designs.
Wow. Okay, so when you're researching or analyzing an IP issue, you might potentially need to consider UK statutes, UK case law, retained EU law, relevant pre-Brexit CJEU judgments, international treaties, and maybe even administrative decisions from the UKPO, the EPO, or the UIPO, depending on the specific right and the question.
It really paints a picture of a complex, multi-layered international legal landscape, doesn't it? The source of the rule or the key interpretation can really vary.
It certainly does.
And then, adding significantly to all this complexity is the sheer pace of change in IP law. The document really stresses this. This subject area is developing rapidly.
Well, that makes sense, doesn't it? Technology, global trade, new business models, the creative industries are all constantly evolving at lightning speed. IP law has to try and keep up.
Exactly. Just think about the impact of the internet, digital copying, biotechnology, software, and now things like artificial intelligence. These all constantly challenge the existing IP frameworks that were often designed for an older analog world.
So the law is always playing catch-up.
To some extent, yes. And because of this constant rapid evolution, the standard advice that's given to all law students, make sure you buy and use the absolute latest edition of your textbook. That advice becomes even more critical, absolutely vital for intellectual property.
Really crucial.
You must check the publication date of the textbook you're using, significant changes to legislation, major court decisions from the UK or relevant EU courts, shifts in administrative practice. These happen all the time, sometimes several times within a single academic year. Older editions just won't reflect the current state of the law. You could be learning rules that are simply wrong.
So relying on an out-of-date textbook in IP isn't just slightly unhelpful, it's actually a serious risk. You could be learning law that's already been changed or overturned.
A very significant risk, yes. You could completely misunderstand the criteria for infringement, miss a crucial new defense, or apply a legal test that a higher court has recently thrown out or significantly modified. The document mentions that useful online legal databases and websites, things like Westlaw, LexisNexis, BLI, the IP Office websites, are absolutely indispensable tools to help you stay current between textbook editions.
Right.
And it says these resources are pointed out in Chapter 3 of the guide, which is another clear sign that studying IP effectively involves using a range of up-to-date resources, not just relying on one static book published maybe a year or two ago.
Okay, so understanding why IP law is challenging its history, its fragmented nature, the level of detail, the diverse and rapidly changing sources, that's the first big step. Now, the source material we're using, this module guide from the University of London, it then provides a really clear roadmap on how to actually use the guide itself effectively to tackle these challenges. And it emphasizes right at the start, doesn't it, that the guide is just that, a guide. It's not a substitute for reading the original legal sources yourself.
That's absolutely key, and the guide is very upfront about this. Its purpose is to help you structure your learning, give you context, explain the tricky bits, and point you towards the essential materials you need to read. But you must engage directly with the cases, the articles, and the specific pages from the recommended textbooks that the guide tells you to read.
So the bits labeled core text or essential reading.
Yes. The document states very clearly that the core text, which typically includes specific textbook readings, lists of the really important cases you need to know, and references to the key statutory provisions and the essential reading sections within each chapter are absolutely not optional extras you can just skim over.
They're fundamental.
They must be taken seriously and studied properly and
Mhm.
diligently. That's where the core learning happens.
It sounds like you really need to adopt a systematic, disciplined approach, working through the guide chapter by chapter.
Exactly. The document really stresses the importance of working through the chapters in the order they're presented, one at a time, to build up your understanding layer by layer. Even though IP is fragmented, the concepts, the legal skills, the way arguments are structured, they do build on each other.
Right.
It even advises explicitly to revisit previous chapters when the guide tells you to, because they act as essential building blocks for understanding the more complex topics that come later. If you skip a chapter or you don't really get the material in an earlier section, you're almost certain to struggle significantly with the later material that assumes you have that foundation.
And it puts a huge emphasis on being able to apply the law, doesn't it? Not just memorize rules or case names,
Yeah.
applying it to new factual situations.
This is absolutely vital.
Yeah.
Probably the most important skill you need to develop, especially thinking about the final exam. The guide says explicitly that the exam usually contains at least as many problem questions as essay questions.
And a problem question gives you a story, a scenario.
Exactly. It gives you a hypothetical story with characters and events and asks you to advise them, essentially acting like a lawyer by applying the relevant IP law to their situation. And the guide states, quite bluntly, that the only way you'll develop the ability to analyze these new factual scenarios and apply the law in a reasoned, structured, lawyer-like way is by consistently attempting and working through the exercises set out in the guide itself.
So doing the activities and questions is how you build that skill.
It's absolutely fundamental. That consistent practice, reading facts, identifying issues, finding relevant law, applying it logically, that's what builds the crucial analytical and problem-solving muscle you need, not just for the exam, but for legal practice generally.
Let's talk specifically about the recommended materials then. The document lists some specific textbooks that form the basis of those core text readings.
Yes, it identifies 4 main recommended academic textbooks that cover the syllabus. It lists Bentley, Sherman, Gange and Johnson's Intellectual Property Law, Bainbridge's Intellectual Property, Llewellyn and Aplin's Cornish, Llewellyn and Alpin Intellectual Property, and Karapapa and McDonough's Intellectual Property Law. These are the primary scholarly sources that the guide's essential readings will direct you to.
Okay, 4 main ones. But just to be absolutely clear, the document doesn't expect you to read all 4 from cover to cover, duh.
Oh, goodness, no. Correct. That would be completely unrealistic given the size of them. For the essential reading sections within each chapter of the guide, it says you should read the relevant passages from at least one of these recommended textbooks.
Right.
The document strongly advises, if it's financially possible for you, to actually buy one of these main texts. Or, at the very least, make sure you have regular and reliable access to them through a library, perhaps the university's online library.
And it mentions one might be available digitally.
Yes, it specifically points out that Bainbridge's text is often available digitally via a platform called VelaBooks through the online library, which could be a very convenient and cost-effective option for many students, worth checking out.
And do these different authors maybe have different approaches or writing styles?
Yeah.
The guide seems to suggest choosing carefully.
They do, and the document is refreshingly honest about this. It explicitly states that different authors will inevitably present the material differently. Some might focus more on certain areas than others. Maybe one is stronger on patents, another on copyright theory.
Okay.
And as a result, the guide says none of the textbooks will be entirely comprehensive on the whole syllabus by themselves, and all of them will probably include some material that is not actually on your specific syllabus.
So you need the guide to direct you to the relevant parts.
Exactly. And because of this variation in style and focus, the guide gives some very practical advice. If you possibly can, before you decide which textbook to buy or rely on primarily, try to look at some sample chapters from each of them.
See which one clicks.
Precisely. See which author's writing style seems clearest to you, which explanation makes the most sense, which one, resonates best with how you learn. Finding the right fit can make a big difference.
That's really good practical advice. What about further reading? The guide often lists extra articles or book chapters under that heading too.
That's exactly what it is. It's supplementary material, extra stuff. These readings are there to broaden your understanding of a topic, maybe offer different academic viewpoints, perhaps dive deeper into a particularly complex issue, or give you more historical background.
But not essential for the exam.
Yeah, generally not directly examinable, no. And the crucial advice from the guide is that you should only really attempt the further reading after you've thoroughly worked through and feel you've got a solid grasp of the core text and the essential reading for that chapter.
Master the basics first.
Absolutely. Prioritize mastering the core concepts and the essential materials before you venture into the supplementary stuff.
Okay. And then there's the statute book. The document seems to really hammer home the importance of this particular tool, both for studying and for the exam.
It absolutely does. And its importance really can't be overstated, especially if you're in a situation where you're allowed to take one into the exam, which is often the case for IP law. An up-to-date statute book that contains the key pieces of IP legislation is described as extremely useful, almost essential.
And it recommends a specific one?
Yes. The recommended one is Blackstone's Statutes on Intellectual Property. These are generally updated every year, which is important given how fast the law changes. And the document says, and uses the word vital, it is vital that you know your way around these statutes.
Right.
It gives a very blunt but crucial warning. It is a complete waste of your valuable exam time taking a statute book in with you if you haven't actually looked at it or practiced using it beforehand.
It's like having a fancy calculator but not knowing where the buttons are when the clock's ticking. You need to be familiar with it to use it effectively under pressure.
Exactly that. You just don't have time in an exam to be frantically flicking through hundreds of pages trying to find the right section. And the document is also very clear that marks are not awarded for just copying out chunks of text from the legislation. That's not demonstrating legal understanding.
So what's it for then in the exam?
It's there as a tool to help you quickly locate the precise wording of a definition or a legal test or the criteria for a specific defense so you can accurately support the legal arguments you're making in your answer. You use it as a quick reference, a reminder tool to ensure accuracy.
Okay.
And the document gives some incredibly specific, really valuable guidance on how to prepare to use it effectively, which is definitely worth repeating. It says you should actively try to ensure that you know where the key provisions are located within each of the main IP statutes.
That's the Patents Act, the Trademarks Act, and the Copyright Designs and Patents Act.
Those three, yes. And specifically, you need to know where to find the rules relating to 4 crucial areas within each act.
Okay, what are the 4 areas?
1, the criteria for protection, what actually qualifies for a patent, a trademark, copyright, etc. 2, infringement, what actions count as violating the right. 3, defenses, the exceptions or justifications for acts that would otherwise be infringement. And 4, remedies, what a court can actually order if infringement is proven, like damages or an injunction.
Criteria, infringement, defenses, remedies for each of the 3 main acts.
Exactly. Knowing where to quickly find the statutory rules for those 4 key things within each of the big 3 acts is absolutely crucial. It gives you a framework for structuring and supporting your answers, particularly for problem questions. It's invaluable advice.
Definitely sounds like it. The module guide also includes these interactive and self-testing features, doesn't it? Designed specifically to help you achieve the learning outcomes. And the document points out these outcomes are about more than just remembering facts.
Yes, the learning outcomes are listed right at the start of each chapter, and they kind of act as your route map. They tell you what you should be able to do by the end of that chapter.
Right. Do, not just know.
Exactly. Notice the verbs they use. It's often things like knowing how to do something, or being able to identify issues, or able to explain how the law works, or critically evaluate a rule, or crucially apply the law.
So it's focused on skills.
Very much so. It emphasizes that the goal is to develop practical legal skills, reflective understanding, and critical thinking, not just passive recall of information. It's essential that you learn to actively use that knowledge, think about its implications, evaluate whether the rules make sense or work effectively, and express your thoughts clearly in proper legal English.
And the guide provides specific tools to help practice these skills, like the activities scattered through the chapters.
Yes, the activities are these practical tasks integrated right into the text, usually based on the material you've just read. This is where you really put your understanding into action.
What kind of tasks?
Well, an activity might ask you to summarize the key legal arguments from a particularly complex or important case you've just been reading about. Or it might challenge you to formulate counter-arguments to a specific legal principle that's been discussed. Or maybe attempt to reconcile 2 court decisions that seem to contradict each other.
Tricky stuff.
It can be. But the great thing is, many of these activities usually have detailed feedback provided right at the end of the module guide.
Ah, So you can check your work.
Exactly. That feedback is an incredibly valuable resource. It lets you check if your understanding was correct, see how your analysis compares to the suggested approach, and helps you refine your legal reasoning and writing skills. They give you concrete practice in formulating structured legal arguments.
And can you do those activities on your own, or is it better with others?
Working through them alone and then carefully checking the feedback is a perfectly good self-assessment method. But the document also notes that it's always really useful, if possible, to tackle these kinds of questions collaboratively with a group of fellow students.
What is that?
Well, discussing the material, debating potential answers, explaining concepts to each other, it can promote much deeper discussion, expose you to different ways of interpreting the law that you might not have thought of yourself, and help clarify points you found confusing when reading alone. Learning together can be very effective.
Makes sense. There are also self-assessment questions, SAQs they're called.
Yes, these are usually shorter, more focused questions that pop up within the text itself. They're designed for you to just quickly pause and confirm to yourself that you've grasped the key issues or concepts that were discussed in the immediately preceding section of text.
Like a quick checkpoint.
Exactly. Unlike the activities, they typically don't require detailed feedback in the guide. They're just simple check-in points for your own comprehension before you move on to the next bit. A quick confidence boost, hopefully.
And then often, right at the end of the main chapters, there are sample examination questions.
Yes. These are practice questions written deliberately in the style you are likely to find in the actual final examination. So, a mix of essay questions and problem questions.
And the guide has strong advice on how to use these.
Very strong advice. It strongly recommends attempting these sample questions under mock examination conditions.
Meaning timed, no notes.
Exactly. Find a quiet place. Allocate the proper amount of time you'd have in the real exam. For example, 45 minutes per question if you have 3 hours for 3 questions. Put your notes and textbook away, only using your allowed statute book if it's an open book exam, and attempt to write a full answer.
Why is that so important?
Because doing this is critical for developing your ability to think clearly under pressure, to quickly spot the relevant legal issues in a complex factual scenario, to structure a coherent legal argument within tight time limits, and to articulate your analysis effectively and concisely. It's the closest you can get to simulating the real exam environment.
And it helps you find your weak spots.
Definitely. It's the best way to identify areas where your understanding isn't solid enough yet to perform well under pressure. The document also mentions that some introductory chapters might not have sample questions, perhaps because they cover background material not directly examined. But it warns strongly against skipping these foundational chapters because the understanding you gain there is absolutely essential for tackling everything that comes afterwards.
Okay. So pulling all these study strategies together, using the guide properly, focusing on the core readings, doing the exercises and activities, getting really familiar with your statute book. How does this prepare you for the final examination itself, according to the document's description of the exam?
Well, the document describes the final examination as a timed, unseen paper, a standard format for law exams. You'll be presented with a paper containing a total of 6 questions, which will aim to cover a range of topics from across the whole syllabus. And you are required to answer 3 of those 6 questions.
3 out of 6. And you can choose any 3.
Yes, the choice is completely unrestricted. There are no compulsory questions, no sections you have to answer from. You simply choose whichever 3 questions out of the 6 you feel most comfortable and confident tackling.
And the types of questions.
It will be a mixture. The paper will contain essay questions, which ask you to discuss, explain, and critically evaluate legal principles or areas of law. It will also contain problem questions, presenting those factual scenarios for you to analyze and apply the law to advise the parties involved. And potentially, there might be questions that combine elements of both essay and problem styles.
And crucially, you absolutely cannot predict which specific topics from the syllabus are going to pop up on the paper in any particular year. No topic spotting.
No, the document gives a very firm warning against trying to guess or spot topics. It explicitly states that, given the breadth of the syllabus, not every single topic can possibly be examined in any single year. And therefore, you should absolutely not regard any particular topic as being somehow guaranteed to appear on the exam paper.
So focusing only on last year's topics, or topics you think are due, that's a bad idea.
A very dangerous strategy, yes. Relying on predictions or revising only a narrow subset of the syllabus is risky because you might find none of your chosen topics come up, or they come up in a way you didn't expect. The clear advice is that comprehensive study across the entire syllabus is essential to maximize your chances of finding 3 questions you can answer well from the choice of 6 provided.
Spread your bets, basically. Cover the field.
That's the safest approach.
And we have already stressed it multiple times. But it seems so important, it's worth repeating one last time, specifically in the context of the actual exam. The role of that statute book.
Absolutely. Cannot emphasize it enough. It is allowed in the examination room, assuming standard regulations apply. But as we've said, it is vital that you know your way around it before you walk into that exam hall.
Practice using it.
Yes. It's there as a reminder tool, helping you recall the precise statutory wording for accuracy. It is not a source for copying out large sections of text that won't get you marks and wastes precious time.
And that golden rule again.
And that golden rule again, that invaluable piece of advice from the document. Make sure you know where to find the key provisions in those 3 principal statutes: the Patents Act 1977, the Trademarks Act 1994, and the Copyright Designs and Patents Act 1988, relating specifically to those 4 crucial areas: criteria for protection, infringement, defenses, and remedies.
Criteria, infringement, defenses, remedies. In the big 3 acts.
Having that knowledge mapped out in your head, or even tabbed in your statute book if allowed, will be incredibly helpful for quickly finding the relevant law and structuring your answers, especially for problem questions, where analyzing those 4 elements is often the core framework of your legal advice.
Fantastic. Well, we have covered a substantial amount of ground in this deep dive into the challenges of studying intellectual property law, drawing directly from the really helpful insights provided in the University of London's material.
We certainly have.
We've seen it's this dynamic, evolving field with roots deep in practical commercial application. It's structured around these quite distinct legal rights, patents, designs, copyright, trademarks, confidentiality, each presenting its own unique set of complexities and learning hurdles.
And we've explored how it draws its rules from a really diverse range of sources, not just English common law and statutes, but also international treaties and, significantly, the continuing influence of EU law, even post-Brexit. And layered on top of all that is the sheer speed at which it changes.
Right. But perhaps most importantly, we've highlighted the strategic approach that the guide recommends for tackling these challenges head-on.
Yes, using the module guide itself as your essential roadmap, committing fully to the core text, the essential readings, and crucially, the practical exercises and activities it prescribes.
Recognizing you absolutely have to stay current with the latest legal developments, using up-to-date textbooks and online resources.
And becoming intimately familiar with your statute book, knowing it inside out, especially where to locate those key rules on criteria for protection, infringement, defenses, and remedies in the main acts.
It seems really clear from the guide that success in mastering this subject comes not from just trying to memorize vast amounts of information, but from really understanding the underlying structure and the rationale behind the different IP rights.
Yes, and recognizing the specific intricacies and challenges that each one presents.
And then consistently practicing the application of the law to new facts, developing that crucial analytical skill, thinking like a lawyer would need to think.
Indeed. And that rapid pace of change we kept mentioning, the constant evolution driven by technological innovation and new forms of creativity, it raises a really fascinating fundamental question to think about as you continue your studies in this area.
What's that?
Well, how might emerging technologies think about artificial intelligence that can generate art or write code? Or entirely new digital asset classes like NFTs, non-fungible tokens? How might these things really push the boundaries of our existing IP categories?
Could they break the current system?
Possibly. Might they challenge our very definitions of fundamental concepts like authorship or invention or originality to the point where the old rules just don't fit anymore? And if so, might that necessitate the development of entirely new forms of legal protection in the future, things that don't neatly slot into our current boxes of patent, copyright, or trademark?
That's a great, really forward-looking thought to leave people mulling over as they delve deeper into this fascinating subject. We sincerely hope this deep dive has given you a solid foundation and, importantly, a clear strategy for understanding and succeeding in intellectual property law, equipping you with both the knowledge and the right approach.
And just to reiterate, this session was created purely for educational purposes, drawing solely from the excellent provided material from the University of London, and we thank them again for making it available.
Absolutely.
Once again, this deep dive was brought to you by Sinorbit Academy, Sri Lanka.
And from both of us, we're wishing the very best of luck for all of you preparing for your studies and, of course, for the exam. Keep diving deep.